Hello everyone, I'm Dr. Mangal Singh Bisain, Associate Professor at Department of Law, School of Legal Studies, Central University of Kashmir. In today's session, we are about to explore a landmark piece of legislation that plays a crucial role in shaping safer and more equitable kind of a work environment in India, right? Especially for women, right? Exclusively for women, right? And the piece of legislation is the Sexual Harassment of Women at Workplace Act of 2013, also called as POSH Act, POSH. Right? Now, this law was a major step forward in acknowledging the rights and the dignities of women, of a working women. Right? It not only defined what constitutes sexual harassment, but at the same time, it also lays down the duties of the employers and the mechanism of the grievances which a woman may have at her workplace. Over the next few slides, we will understand the background, the provisions, procedures, and challenges related to this act. We will also discuss the significance, the importance of creating a workplace culture rooted in respect to, let's say, uh, 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 inclusiveness and accountability. Okay, so with this said, let's begin by understanding why this law was necessary and the context in which it was introduced. Okay, now the law was enacted in the year 2013 with a primary aim to ensure a safe and a secure working environment for women. Such an environment which is free from any form of sexual harassment. Right? Until then, prior to 2013, India had no specific legislation as such to address this issue. This somewhere somehow left the working women vulnerable and often without proper redressal mechanism. This act draws its roots from a very landmark judgment which was pronounced by the Supreme Court of India in 1997. That is Vishakha and others versus State of Rajasthan. We are going to discuss this case in detail later on, right? But this was the case which was the foundation, right, of the Protection of Women from Sexual Harassment at Workplace Act. This was a response to the shocking gang rape of Banwari Devi, a grassroots level social worker who was targeted for stopping a child marriage. There was no framework at that time to hold the perpetrators accountable in the context of workplace harassment. Right? Now, recognizing this gap, the Supreme Court let down Vishakha guidelines. Right? Remember, the title of the case is Vishakha and others versus State of Rajasthan, and the guidelines which are issued in this statute is called as Vishakha guidelines. Right? These guidelines are mandatory procedural safeguards for employers to prevent and did redress sexual harassment at workplace. Now, these guidelines had the force of law until Parliament passed the Act of 2013, the present Act, right? But the guidelines are still effective; they are still required to be followed. Now, the court explicitly stated that sexual harassment at workplace violates fundamental rights guaranteed under the Constitution. Fundamental rights, particularly Article 14, Article 15, Article 21, right? Article 14, that is right to equality. Article 15, that is a prohibition of discrimination on the grounds of sex. and Article 21, that is right to life and personal liberty. Right? So, in a sense, this Act of 2013 is not just a workplace behavior, it's about protecting the fundamental rights and at the same time, human dignity of a woman. It is about recognizing recognizing that safety is not a privilege but a right, and that no woman should be forced to choose between her career and her dignity. Okay. Now, with this, let's move on to the objectives of the Act. Uh, the Act primarily centers around three key goals, right? Three key objectives: prevention, protection, and redressal. Right? I repeat, the Act revolves around three important aspects, that is, prevention, protection, and redressal. Firstly, the Act aims to prevent sexual harassment at workplace. This is a kind of a proactive step, right? This is a proactive step. It's not just about punishing the wrongdoer, but also creating a system or a sense of awareness and a culture that actively discourages inappropriate conduct in workplaces. Right? Employers are now required to conduct sensitization programs and display policies clearly in the workplace. Secondly, we seek to protect women from such acts uh, by recognizing their right to safe and dignified working environment. Now, this protection is not limited to salaried or permanent employees only. This provision, this protection, or this right extends to, let's say, interns or volunteers or part-time workers or domestic workers, and even to the women who may not be directly employed by the organization, but interact with it in the course of their work, maybe kind of a freelancer, right? So all these different categories of working women are taken care of under the statute. Thirdly, the Act provides a structured and a time-bound redressal mechanism. Structured and time-bound redressal mechanism for women to, let's say, report an incidence of sexual harassment and to resolve the complaints relating to sexual harassment. The statute here lays down clear procedures for forming internal committees, conducting enquiries, and delivering outcomes. This procedural aspect of the Act somewhere somehow ensures that justice is easily accessible to a woman, it is fairly exercised, and at the same time, it is in the hands of efficient authority. Okay. Now, to understand the scope of this law, it is essential to clearly define as to what amounts to sexual harassment. Okay. The points that you see are some of the contents of the definition of sexual harassment. Now, the Act itself, the Act of 2013, that is Sexual Harassment at a Workplace Act of 2013, provides a broad and very inclusive kind of a definition, recognizing that harassment can take many forms, right? Forms which are not, which include and not limited to, let's say, just physical abuse, right? Or it may include, let's say, verbal or visual or psychological harassment as well, right? According to the definition given under the statute, the first one, that is physical contact and advances. This includes unwelcomed physical gestures or, let's say, inappropriate touching, Such touching which invades a woman's personal space and makes her uncomfortable, right? So if a woman is feeling uncomfortable because of the physical touch of a person, it may amount to harassment. On the contrary, if a woman is shaking hand with the other colleague, then it does not come under the category of sexual harassment, right? So comfort of a woman is very much important. If a woman is feeling uncomfortable, if the touching is inappropriate, then it may fall under the category of sexual harassment at work. Similarly, demand or request for sexual favors, this means that uh, uh, this is often seen in cases where a woman is pressurized or coerced into having a sexual activity. Sometimes this happens in exchange for professional benefits, let's say like a promotion or some kind of a favor, right? A favorable project, favorable assignment, favorable posting, right? Or even in some cases, it is seen it is just for job security. Right? This is a classic example of what is known as quid pro quo harassment. Right? Now, making sexually colored remarks is also covered under the definition of sexual harassment. The remarks which are offensive or suggestive comments or jokes or statements that have sexual color, sexual undertone, and it creates a a hostile or an uncomfortable work environment. Right? Such remarks may fall under the category of sexual harassment. Showing pornographic material, obscene literature to a woman, even if not directly at a woman, the act of displaying pornographic content on, let's say, screens or through messages or in any kind of a printed form, right? A digital or a printed form in, let's say, a shared workplace is a clear form of sexual harassment, right? Is a clear form of sexual harassment, falls under the definition of sexual harassment. And finally, any other unwelcomed physical, verbal, or non-verbal conduct of sexual nature, right, come under the category of sexual harassment. Now, this clause ensures that the definition is not restricted to a fixed list of items, right, to fixed conducts within the work environment. It includes behaviors such as it also includes behaviors such as staring a woman, right, leering, right, making gestures, sending sexually suggestive texts or emails, and many more of such categories. Many more such kind of actions may come under the category uh, of the of sexual harassment. Right? Any action which is unwelcomed and has a sexual nature, sexual orientation, can be presumed to be of a nature of sexual harassment under the definition. Now, here, what is important to remember is that the impact on a woman matters more than the intent of the perpetrator. If the behavior is unwelcomed, intimidating, or makes the workplace hostile, it qualifies as a sexual harassment under the law. Now, this comprises a definition. This comprehensive definition, which is given under the statute, is what empowers the woman to recognize and report behavior that may have been normalized or dismissed in the past. Right? Past in the sense before enactment of the statute. Okay. Now, if we talk about the scope and applicability of the statute, one of the strengths of the POSH Act is its wide and inclusive applicability. The law is designed to protect women in all kinds of workplaces. Workplaces may be formal, may be informal, all kind of workplaces, regardless of the nature of employment as well, right? Or the sector of work. If we break down the scope and applicability, then applicability to all workplaces, both organized and unorganized sectors. This means it is not just limited to corporate offices or government departments. It applies to shops, factories, educational institutions, hospitals, NGOs, startups, right, and many more such places. Construction sites, homes, right? All these workplaces fall under the category of workplace, and they are governed by the statute, right? It covers both public as well as private sector employees, whether a woman is working in a multinational company or in a startup or a government office, small local businesses, right? She is protected under the law. The employer in all these cases is responsible, irrespective of the size of the organization or the type of organization, right? Type of business. It also extends protection to domestic workers, interns, and even customers or visitors as well. Even customers and visitors are covered under the statute if the harassment takes place at workplace. The definition employee under the act is very broad. It includes part-time workers, temporary staff, apprentice, trainees, volunteers, and so many different things. Right? Even if a woman is not directly employed by the organization, for example, an intern, a delivery execution, or a consultant, she is still covered under the statute. Moreover, if a woman enters a workplace, say for example, let's say a client or customer or simply a visitor, right, and she experiences harassment at that place, the organization is still accountable. The organization can still be penalized. Now, this broad scope ensures that no woman is left out of the law's protection, regardless of her own position or the system or the settings. It enforces the fundamental idea that every woman has the right to work and move freely without fear or discomfort. Now, by making this act so widely applicable, the law acknowledges the diverse and often vulnerable positions of women, the positions which a woman occupies in a workplace as of today. Now, if we talk about some of the key provisions of the statute, then uh, mandatory internal complaints committee. Right? The key provisions we are talking about here is basically the mechanism it puts in place, the statute puts in place for, let's say, prevention or prohibition and redressal, prevention, prohibition, and redressal of the complaints relating to uh, sexual harassment at workplaces. Right? So the first one, mandatory internal complaint committee. Now the act makes it compulsory for every organization with 10 or more employees to constitute an internal complaint committee, also referred to as ICC, right? 10 or more employees. Now, this is a body responsible for, let's say, receiving, investigating, and resolving complaints of sexual harassment. Without this committee, an organization is in direct violation of law, right? The ICC must be all inclusive, impartial, and trained in handling sensitive complaints. That is important. Now, the local complaint committee, second one, that is for women working in an establishment with fewer than 10 employees or in the unorganized sector where an ICC cannot be constituted, uh, the law provides for the constitution of local complaints committee. Right? So basically, the this ensures that Even a woman who is working, let's say, as a domestic worker or a helper or a street vendor or freelancer are not left out. Right? They are also given due protection under the law. Right? The local complaints committee is primarily chaired by the district officer and includes a woman from an NGO. And other members of the committee, right, other members of the committee must be familiar with the issues of women's rights. That is a very basic, very fundamental qualifications to become a member of a committee. Now, the time-bound inquiry and resolution, the law emphasizes swift justice. Once a complaint is received, the ICC, that is Internal Complaint Committee or the local complaint committee. So once a complaint is received, these committees must complete the inquiry within 90 days. That is important. The employer must act on findings within 60 days, 60 days of receiving the report. Appeals can be made within 90 days of the decision. Right? Remember the timeline. First timeline is as soon as a complaint is received by the committees, right? Either ICC or LCC. Right? As soon as a complaint is received, the inquiry must be completed within 90 days. Secondly, after completion of the inquiry, a report is required to be submitted to the employer, and the employer should take decision, right, within 60 days of receiving of the report. Against the decision of the employer, if the accused intends to file a complaint, file an appeal, right, then the appeal must be filed within 90 days of that decision, right? 90 days of that decision. Now, this you can see that this structured timeline helps prevent unnecessary delays and ensures that the process is not dragged or not dragged indefinitely, which can be re-traumatizing for the complainant herself. Right. And lastly, protection against victimization. Now, the Act provides protection not just from harassment, but also from retaliation. Right? Not just harassment, but also retaliation. A woman, we are talking about a working woman here, right? A woman who files a complaint cannot be demoted, transferred, terminated, or threatened as a result of her actions. Similarly, witnesses and members of ICC are protected from intimidation or adverse consequences. Now, this clause is crucial because fear of black backlash is one of the biggest reasons why women generally do not come forward. They do not complain, right? So this provision takes care of that fear of a woman. Now, together, these provisions make the POSH Act not just a legal formality, but a functional and enforceable tool, enforceable for ensuring workplace safety and justice to the women. Okay. And now let's talk about the internal complaint committee. Generally, in big organizations, ICC exists, right? So I'm primarily focusing upon this committee. Internal Complaints Committee, the composition, the tenure, the powers. We'll see. Now, this body, the Internal Complaint Committee, is a body that actually investigates complaints, interacts with the complainant, and the respondent and complainant and the respondent, and in some cases, maybe the peers as well, right? So, interaction with the appropriate stakeholders, and finally, submit a report to the employer. Right. If we talk about the composition of this committee, then ICC must be constituted in every workplace with 10 or more employees. Even our university has this ICC, right? Internal Complaint Committee. So every workplace with more than 10 employees, ICC must be constituted. Right? It must be carefully formed to ensure fairness, diversity, and sensitivity. Right? Now, it must be chaired by a presiding officer who must be a woman working at a senior level in the organization. Whoever is the senior most woman in the organization, right? That woman is generally the presiding officer of this committee. Right? There may be more than one senior officers, women officers in an organization, then any one of them can be appointed as a presiding officer. It should include at least two members from among the employees, preferably committed to women's welfare or having legal or social experience. It must also include one external member, someone who is from, let's say, an NGO or any organization which is familiar with the issues of sexual harassment. This external member plays a very crucial role in bringing independence and neutrality to the process, especially in internal biases which may exist. Right. The tenure of ICC, the members appointed in ICC are appointed for a period of 3 years. This term allows for continuity and helps member build their own necessary experience in handling complaints with utmost professionalism and empathy. Right. So tenure has been described under the statute of 3 years. Powers. ICC has powers similar to a civil court. Civil court constituted under the Code of Civil Procedure 1908, 1908. Right? What does it mean? It means that an ICC can issue summons, right? It can call the witnesses, it can call for documents or evidences, uh, it can examine persons under oath. These powers are essential to carry out a proper and fair inquiry. While the ICC is not a judicial body, not purely a judicial body, it has enough authority to investigate effectively and reach a reasoned conclusion. Right. So basically, overall, ICC is the heart of the grievance redressal process. Right. But what I feel is that its effectiveness largely depends upon how well it is constituted, how sensitively it is handling the cases, and how committed the employers in an organization are in implementing its recommendations. Right? That is the role of ICC. Now, procedure for complaint. Okay. Now let me walk through the complaint and inquiry process, which is designed to be clear, time bound, and sensitive to the needs of the complainant. Right? A woman who experiences sexual harassment at a workplace must file a complaint within a span of 3 months. Right? Within 3 months from the date of the incident. This is something which is expected from a woman. Right? If there are multiple incidences, the 3 month period will be counted from the last occurrence. However, recognizing that it can be difficult to come forward due to trauma or, let's say, fear or stigma, the ICC has the discretion to extend this period of 3 months up to 6 months, right? Provided there exists a valid reason, and the reason is required to be brought before the ICC by the woman herself, right? Or through some representative. Now, the mode of complaint may be written or oral. Ideally, the complaint should be in writing. But if the complainant is unable to write it by herself, maybe she's an illiterate, or maybe she is not in a position to write as of then, right? So if she's unable to write, then ICC is a duty bound to assist her in documenting the complaint. This is an important provision because many women, especially from from marginalized background, right, may be hesitant, or they may be unable to articulate their complaint formally, right? Now, regarding conciliation, before starting the formal inquiry, the ICC can offer the option of conciliation, but only if the complainant requests to it, right? Only if the complainant requests. Importantly, this cannot involve any monetary settlement, right? No money can get involved in the conciliation process. The purpose of conciliation is basically to reach an understanding, or an apology, not to pay off the issue, right? Otherwise, it will become more of a monetary, more of a source of income for working women to extort money from their employers. Right? This should not happen. If conciliation is successful, the inquiry ends at that point of time. If it is not, if the conciliation doesn't work, then a formal inquiry should be started by the ICC. Once an inquiry begins, it must be completed within 90 days. That is something that we discussed in the previous slide, right? The ICC submits a report along with its findings and recommendations to the employer, who then has 60 days to act on it. This timeline ensures that the complaints are not kept pending indefinitely, which could cause further trauma to the complainant. Right. So overall, the process is designed to balance fairness with speed, ensuring that justice is neither delayed nor it is denied, while also uh, being not being not intimidating, and it should be supportive to the women who is involved in the act of sexual harassment, right? Means means the victim of sexual harassment at workplace. Now, if we talk about the duties of the employer under the POSH Act, the responsibility of ensuring a safe and harassment free workplace lies heavily on the shoulders of the employer. The law is very clear. It is not enough to react after an incident. The employer must take active, ongoing steps to prevent harassment from occurring in the first place. Right? How he can achieve this task? Right? First one is by constitution of ICC, Internal Complaints Committee. As we have discussed earlier, every organization with 10 or more employees must set up an ICC. Failure to set up an ICC is a direct violation of the Act, and this can lead towards a penalty, right? Penalty to the employer of the organization. The ICC must be properly composed, trained, and capable of handling complaints with sensitivity and fairness. That is something that we discussed in the previous slides also. Right now, duty of the employer to organize awareness programs. So here the employees are also required to conduct regular workshops and sensitization programs to educate employees about educate his especially the female employees about what constitutes sexual harassment, how to file a complaint, the functioning of internal complaint committee, the rights of the complainant. All these things, right, target at all levels of employees, right? The target should be all the employees, especially the women employees working in the organization, from senior management to the interns. All the different levels should be covered in this awareness program, right? The act also mandates that the employer must display at some conspicuous place in the in the what do you say, in the place of work, a banner or poster which clearly reflects as to what amounts to sexual harassment, right? The consequences, the poster may contain the consequences of must contain the consequences of sexual harassment, the composition of ICC, the procedure for filling for filing a complaint. Then this poster, right, should be clearly visible to to the people passing by, right? And this visibility serves as both a deterrent and an assurance that organization takes law very seriously. In cases where the act of harassment also constitutes a criminal offense, such as, for example, let's say physical assault, right? Hurt, grievous hurt, injury, right? Stalking, intimidation, some digital offense, which is covered under the Information Technology Act, all these things. So where an act falls under this statute, the statute of POSH Act, as well as some other statute, some other criminal offense, criminal law, right? Then the employer must support the women in filing the complaint with the police also, right? If there is a provision for police complaint. So employer must help the women with that as well, right? The POSH Act does not replace criminal laws. Remember this thing, right? Instead, it is working parallelly with the criminal laws, right? The final intention of the laws is to protect the women's right, both within the workplace as well as outside the work. So, in short, in summary, it is the employer's duty, not the employer's duty is not passive in nature. It is very much active in nature. It's not like it is the ICC who will do all the work. No, the employer is also required to act, uh, be proactive when it comes to sexual harassment at workplaces. Right. This proactiveness may include preventing harassment, enabling redressal, constitution of committees, right? Uh, Awareness programs, and empowering women employees at different levels. Right? A failure to fulfill this obligation can lead to, let's say, fines upon the organization or the employer, cancellation of business licenses, uh, reputation damages, and so on. Okay. Now let's talk about some of the penalties relating to non-compliances. Right. It is important to understand the consequences of ignoring the provisions of this POSH Act. POSH Act provides for strict penalties, right, to ensure that the organizations takes sexual harassment at workplaces seriously. Right. So fine up to rupees 50,000 for non-compliance. So if an employer fails to constitute, let's say, internal complaint committee, does not act in uh, or he does not act on the recommendations which are given by the ICC, or he does not follow the mandatory provisions of the statute, then they can be fined up to rupees 50,000. This penalty applies to the first instance of violation. Right? Remember this thing. Repeated instances is given in point number two, right? But for the first instance, first time offense, the penalty is up to 50,000. If we talk about repeated violations, so if an employer repeats the offense or if the violation continues over time, the law allows for doubled fine, right? Now look at the consequences. First, the fine will be double. Second, there may be cancellation or withdrawal of business licenses, or the registration of the employer himself, right? If it is a some kind of a professional organization. Okay. So these may be the consequences of repeated violations. Now, this provision ensures that the employers treat post compliance not as a formality but as a legal obligation with with actual consequences. Then, if we talk about criminal proceedings, if the incidences also involve offences under some other statute, let's say Indian Penal Code, which is now referred to as Bharatiya Nyaya Sanhita, right? So, if the incidence involves offense under that statute as well, such as, let's say, assault or intimidation or use of criminal force and so on, then criminal prosecution can also be initiated. So, in such cases, the employer has a duty to assist the complainant in filing FIR, first information report, with the police. Right. This is something that we discussed in the previous slide also. So, here the law sends a very clear message that failure to comply is not just a lapse, it's a punishable offense. Right? Compliance is given under the statute is not optional, it is legal, ethical, and organizational necessity. Okay. Now let's talk about some of the challenges with this act. Posh Act, no doubt, was a landmark step in making Indian workplaces safer and more inclusive. But even more than a decade later, its implementation continues to face several challenges. The first one is lack of awareness. Despite the law being in place, many employees, especially women, we are talking about employees, especially women, are still unaware of their rights under the POSH Act. Even worse, in some organizations, it is seen that uh, some organizations themselves are unaware of their obligations to form internal complaint committees, right, and conduct awareness programs. So, without knowledge, rights cannot be exercised. And in such a situation, safety remains very much compromised. Then the second challenge is the fear of retaliation. Fear often keeps survivors silent. Many women who worry that reporting harassment may lead to backlash, social isolation, or even losing their jobs. This fear is especially wrong when the perpetrator is someone in the position of the power. Right? Perpetrator is a position of the power. This silence allows for the harassment to persist uh, behind the curtains or in the shadows. Right? The harassment continues. The perpetrator thrives, and the victim of such offense remains dormant. This generally is seen to happen. Right. The third one is token compliance. Some organizations treat POSH Act as a checkbox requirement, right? Just a legal formality, nothing more than that. That is forming internal complaint committee on the paper, right? Skipping training sessions or conducting superficial inquiries and so on. This kind of formality or tokenism undermines the entire process of the law. It defaults the purpose of law. And the last one is the need for cultural change. At its core, this is not just a legal issue, right? It's a crucial one. It's a cultural one. It's not just a legal issue, but it is a cultural one, right? A respectful and safe workplace must go beyond rules and committees. It requires a swift shift in the mindset of among the people who are working at such place. one where dignity, equality, and zero tolerance for harassment are deeply embodied. Such kind of workplace is a need of time. Laws like POSH Act are powerful tools, but tools need to be used properly and effectively. Okay. Now let's talk about some of the case studies or case laws relating to the POSH Act. Now, as we discussed in the very beginning, POSH Act didn't emerge in isolation, right? It was born out of judicial activism, judicial pronouncement, and growing recognition of the need to protect women at workplaces. So these are three important case laws. There are many more cases relating to protection of women from harassment at workplaces, but these are the three reference cases that I have taken. Right. First one is Vishakha versus State of Rajasthan, the case of 1997. Okay. 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 The case of 1997. The case was filed after a brutal gang rape of Bhanwari Devi, a social worker in Rajasthan. Right, she was a social worker in Rajasthan. She was targeted by the locals, right, when she attempted to prevent a child marriage. At that time, there was no specific law to address sexual harassment at workplaces. Right. The Supreme Court, in this case, responded by laying down Vishakha guidelines, a set of preventive and remedial measures for workplace harassment. Now, these guidelines recognize the sexual harassment as violation of fundamental rights guaranteed under under Article 14, 15, and 21 of the Constitution. Now, these guidelines serve as a law for the land until POSH Act came into force in 2023. The second case is of Medha Kotwal Leela Lele versus Union of India, that is of 2013. Now, again, this case highlighted the gaps in implementation of Vishakha guidelines. In this case, social activities, Medha Lele brought to the court's notice that many institutions had not implemented the guidelines properly. The Supreme Court took a firm stance, stating that non-compliance would attract action for contempt of court. Right? This case pushed the government and organizations to take implementation of the statutory provisions very seriously, and eventually this led to passing of the POSH Act as well. The third one is the Appraisal Export Promotion Council versus AK Chopra, the case of 1999. This case further expanded the scope of what constitutes sexual harassment. Right. In this case, the Supreme Court upheld that dismissal of a senior officer who had made unwanted advances towards a female employee. Right? The Supreme Court upheld such dismissal. The court held that even if there was no physical contact, but sexually colored behavior that that violates a woman's dignity amounts to harassment. Now, again, this judgment reinforced the idea that workplace harassment doesn't always look violent. It can be subtle. It can uh, be verbal. It can be psychological in nature as well. Now, these cases somewhere somehow reminds us that behind every law is a human story of let's say courage or injustice or fight for dignity. These cases somewhere somehow also remind us that law alone are not enough. It is up to all of us, it is up to the society at large to ensure that justice is not just written, but it is lived. Okay. So we have come to the conclusion of the session. So, in conclusion, in summary, the POSH Act, that is the Sexual Harassment of Women at Workplace, Prevention, Prohibition, and Redressal Act of 2023, is more than just a legal document. It is a milestone in India's journey towards gender justice. Right? It acknowledges a long-standing issue and gives women a framework to speak up, right? To seek redressal, right? And to claim their right to work with dignity. But as I said previously, law is only as strong as its implementation. Awareness, sensitivity, accountability are the real building blocks for a safer workplaces. Therefore, the organizations must go beyond formalities, and at the same time they must foster environment that environment in which a woman feels protected, she feels safe, and she feels empowered. Okay, okay, with this, I conclude my session on the topic. Thank you. Thank you very much.